Parliament arsonist, the man accused of setting fire to Parliament, Zandile Mafe, has claimed that the addition of a charge of terrorism is a trumped-up strategy to make his bail application more difficult. He was meant to have his urgent bail application heard in the Western Cape High Court on Saturday, but instead his legal team has opted to first challenge the decision to refer him for psychiatric evaluation. The legal analyst, the attorney Benedict Phiri, now joins us to discuss the implications of Mafe's allegation. Benedict, good evening. Thank you for your time. It's nice to see you face-to-face in our studio. If a judge orders that a suspect or a person implicated in a crime must first go for psychiatric observation, how difficult is that to challenge?
Well, the question really is whether the judge had sufficient grounds to order that. Now, we know under the Criminal Procedure Act that all that a judge needs is some kind of a prima facie evidence to show that a person may not be able to understand the implications of his trial and be fit to stand trial. And this is what the judge has done in this particular instance, to say this evaluation is for the purposes of confirming whether Mr. Mafe is actually fit to stand his trial at this particular point in time.
So there are two things here. There are two legal things that would happen. There's the trial, but the bail application comes before the trial. As I understand the law, if it's not a Schedule 6 offence, I suppose burning Parliament down may be, but it's not technically, as I understand it. The onus would be to grant someone bail. Can the judge decide that you need to have the psychiatric referral first, that he needs to understand the suspect's state of mind before hearing the bail application?
I think the two are not as related. I mean, a bail application is a self-standing thing, and ultimately what the judge looks at is whether it's in the interests of justice that a suspect be granted bail. Now, what has happened in this case with the addition of the terrorism charges, it becomes a Schedule 6 offence, as you've indicated, and then the onus shifts on Mr. Mafe to show not only that it's in the interest of justice that he be granted bail, but also to show exceptional circumstances why he should be granted bail. A judge does have to consider within the interest of justice test whether a suspect will be a danger to himself or a danger to society. So that forms part of the test. So part of the psychiatric evaluation may play into the bail application, but it's quite a limited inquiry into really the holistic nature of determining whether bail should be granted or not.
It must happen all the time that a judge needs a report on someone's state of mind, psychiatric health, mental health, whatever you want to call it, before they actually go through the bail and court procedures.
Certainly within a trial context, that does happen. But from a bail perspective, it is two separate aspects, because ultimately you're asking yourself, is this person, should they be incarcerated? You're playing a balancing act as a judge between the interests of the public in seeing a crime prosecuted eventually and those that are seen to be committing crimes being incarcerated, as well as the overriding right to freedom of movement and not being detained without a trial. So that's the balancing act that the judge has to undertake in this instance. And the fact that a person may or may not be mentally sound may not influence whether it's in the interest of justice that you are let out on bail pending the trial, even though it may have a bearing on whether you are fit to stand trial in the long run.
For a bail application, so a psychiatric observation generally seems to be 30 days. It certainly is in this case. Would it be a better legal strategy to go through that? Now, there would be the loss of 30 days of freedom. I don't want to underestimate that or to sort of downplay that in any way, but it is 30 days of loss of freedom, I presume cared for in a facility, and then to challenge. Then everybody would kind of know where they are. The problem, of course, comes if the person, so Mafe in this case, believes that they are perfectly sane, and the psychologists and the psychiatrists disagree.
Yeah, I think, well, it may be a better legal strategy, because ultimately if the outcome of that psychiatric evaluation is that you're not fit to stand trial, then, you know, Mr. Mafe will not see trial until such time as he is fit to stand trial. So it may be that that is the better option to go. I think what Mr. Mafe's lawyers, though, are doing here are saying that in the first place, there was a problem with that referral to psychiatric evaluation. So from a legal perspective, the judge didn't actually have the legal grounds to do that. And that's a problem in and of itself, because that obviously means that we are in a process which may not be legally sound. So if it's not legally sound and he believes so, I believe then it's actually a good thing to challenge that, rather than then end up in a process which may have not started off legally sound in the very first place.
Most people would think that when Parliament burns down and someone is arrested, that the charge of terrorism is almost automatic. Parliament is a national key point. I've been there for many state events, and the security around it is just unbelievable. But the security is there not really to protect the building, to protect the people. As far as I know, nobody was hurt, nobody was killed in this. Can you still be found guilty of terrorism if no one is hurt?
Yes, you can still be found guilty of terrorism if no one is hurt. Parliament as an institution, as a building, is an important feature in the country. And if you look at the Terrorism Act, any substantial damage to property falls within the first part of the test. There are other aspects of the test that need to be satisfied. So notwithstanding that Mr. Mafe may have, allegedly caused damage to Parliament, there still needs to be an element of coercing government or the public or creating fear within the public's minds. And over and above that, more importantly, there needs to be an element of propagating a particular ideological point or religious. So we don't know whether those elements are there in this particular instance. We know that there might be the fire that has happened, but we don't know whether Mr. Mafe was acting from a political point or an ideological viewpoint. We don't know whether this was intended or reasonably intended to cause fear in the public or coerce the government into doing something or the other. And those elements need to be in place for the charge under the Terrorism Act Section 2 to actually be successful.
Is it surprising that the state didn't start with terrorism? They've added the terrorism charge. It's Parliament. You would have thought it would be there from the beginning.
I don't think it's surprising. I think it became an afterthought. It was arson because that's straightforward. But then the terrorism, I think it became an afterthought once the facts started falling into place and you start saying, well, maybe there is an element we can prove, and we can prove these additional elements once we get to ventilate the facts further. So I'm not surprised that they added that as the story unfolds and as they get to know what actually happened. I mean, there is a question whether it'll actually stick, but I would have expected that terrorist charges are actually added as well.
Mafe himself has promised a hunger strike. Now, a hunger strike is quite an extreme action. Certainly hunger strikes have been taken in our history and in other countries' histories for political reasons and to make important political points. But is that likely to bear on the decision about whether or not he is found to be sane?
I think that's a really tough one because, I mean, the question around whether it's fit to stand trial will be a medical evaluation ultimately. And, the reasons for his hunger strike may or may not be, linked to his mental state. He is making a political point in his affidavit. He's saying, I'm a poor person who doesn't always have food, and until this is actually dealt with, I will put myself in the same position I was in and not necessarily have the benefits of prison refreshments, if we call it that.
It now appears that he has contracted COVID-19. And if you look at the timeline, this must have happened in prison. So while he's been in a holding cell or wherever he's been, it's been in the detention of the state, the police service or correctional services. I would have thought there might be a legal obligation on the people who are responsible for him to ensure that he's not infected with COVID. He's not placed in danger of contracting a disease.
I think certainly, the prison authorities, when they were processing him in, would have ensured that, firstly, his health is fine. So you're correct that it's more likely that he contracted in prison, and would have tried to ensure as far as possible that the conditions that he was going to be held in this particular point in time would not endanger himself. I think it's disappointing that, notwithstanding that having had to happen, we don't know if it happened for sure, that is the outcome. But certainly there would have been an obligation to ensure that.
Benedict Phiri, always good to see you. I really appreciate you coming in. Thank you very much indeed, the legal expert and attorney.